some funny comments, well, comments that I think are funny. But Steve's going to take the bulk of it. Anybody has any question anytime, feel free, raise your hands here on Zoom. If you have any questions, I assume that they can raise hands. Yeah, just wave and we'll call on you. Here we go. All right. This is Steve. Take it away, Steve.
Good afternoon. Since I've been asked to put some trivia questions into my presentation, we're going to start out with that. By a show of hands, how many of you have ever seen the movie The Incredibles? Okay. Now, for those of you who saw the movie, do you remember who played Mr. Incredible? That is correct, but it's Craig T. Nelson, but I'll give it to you.
Coach.
The second question is, what was his profession when he wasn't Mr. Incredible? That's correct. He was an insurance adjuster.
Who called the who? There you go. There's a $25 chip.
And the last question, which is going to tie it all in together, why was he fired? That is not correct. Why was he fired? That is correct. What he was actually fired for, though, and I'll translate that to some extent, was he was actually helping the insureds present their claims and paying them on an honest basis. So he was fired. So in fact, he was fired for not committing bad faith when the company wanted him to commit bad faith. And that is actually a microcosm of the problem in our industry. Because the reality is there are few and far adjusters who are willing to adjust claims honestly. Now, I can truthfully say I have never seen a claim that was handled properly from beginning to end, and that includes a claim where they paid policy limits. Because in the claim where they paid policy limits, they did not voluntarily pay the 5% override for debris removal. That was built into the policy. Now, that was an Allstate policy. Now, the reality is we all hope that the implementation of laws precluding bad faith is actually going to curb these kinds of practices. But anybody who believes that is frankly naive, because it's not going to happen. And the reason why it's not going to happen is because so few people challenge their insurance companies when they adjust a claim. And even fewer of those people file suit. And even fewer of those people include a claim for bad faith. And even fewer of those people take it through to trial. Now, one of the problems in bad faith litigation is that there's an incredibly high burden of proof in these kinds of cases. So it's rare that you can take a case to trial and win it on bad faith. And I don't care what state you're in, that is going to be true. So what the insurance companies have done is actually built in bad faith into their business model. And it comes across in two ways. First is the claims that should be covered and which are denied, but the more insidious version of bad faith are the claims that are intentionally undervalued. Now, if you think about it this way, you'll understand what I'm talking about. Assume an insurance company, and for lack of a better word, a better company, Allstate. Let's assume over the course of a year, they're presented with 1 million claims that they found coverage for. And in each of those claims, they underpaid the claim by just $1,000. That is $1 billion of extra profit to Allstate. And if you think that sometimes, particularly when you're dealing with Allstate, that it's like dealing with somebody who's who is acting like he's taking money or out of his or her pocket. In many of those cases, they actually are. Because Allstate adjusters are offered, and many of them have, Allstate stock as part of their 401k programs. So the profitability of Allstate directly impacts their net worth. Now, personally, I believe that in and of itself is a bad faith practice, but no court yet has agreed with that. But the reality is they have a financial stake in the outcome of the claims that they're adjusting. Now, we see bad faith many times. And, you know, it's kind of almost like when Justice, I think it was Justice Warren said, I may not be able to define pornography, but I know it when I see it. Bad faith is kind of hard to define, but you know it when you see it. But it is not the mere poor handling of a claim. It is not merely making mistakes, because the reality is mistakes are made in almost 100% of the claims on the part of the insurance company. The difference between a claim that is poorly handled and one that involves bad faith is usually boils down to intent. The courts will not find that an insurance company acted in bad faith unless you can prove that their conduct was either intentional or reckless. Now, the standard for bad faith is different in every state. Now, the two that I'm personally most familiar with are New Jersey and Pennsylvania. And the difference between New Jersey and Pennsylvania is that, as I understand the New Jersey bad faith statute, the claim has to be denied, and it has to be so obviously wrong that there can't even be any question about whether the claim should have been covered. Pennsylvania is a little bit different and a little bit easier. And the standard, what you have to prove in Pennsylvania is that a client was denied, not a client, excuse me, an insured was denied a benefit that was owed to him or her under the policy, and it was done intentionally or recklessly by the insurance company. Why does this become important as the distinction? If in New Jersey you have to prove the claim it has been denied as a part of your bad faith claim, that eliminates a lot of bad faith conduct that would be actionable in Pennsylvania. It's like in Pennsylvania, if an insurance company denies the right of somebody to go to an appraisal on a covered loss, that can be bad faith. But that wouldn't be bad faith in New Jersey if you have to prove that the claim was denied before you can bring a bad faith claim. Now, most of the states that I am familiar with follow a more of a pattern like Pennsylvania does. And it can be anything that's part of the adjustment process that can be deemed to be bad faith. Again, I gave you an example a moment ago where an insurance company denies the right to go to appraisal. I actually have a case in litigation now in Lancaster County where that is one of the issues of bad faith. Insurance company refused to go to appraisal because they said the entire claim had been paid. Entire claim wasn't paid. What had happened was a contractor's estimate had been submitted. They paid the contractor's estimate, but that wasn't the entire claim. So they refused to go to appraisal on that. There are other examples, again, that I can give you right now. And one of the most insidious ones is one that I'm dealing with in a case right now. And that is, in fact, two cases right now where the insurance company denied a claim over the phone without doing an inspection. In both circumstances, it involved water that had infiltrated the basement. No, and in fact, one of them is above ground, and I haven't even done the evaluation yet on the coverage issue on that because I haven't seen the policy, nor do I know all of the facts with regard to the claim. But in both circumstances, the insurance company denied the claim over the phone with no inspection. Now, in one of them, I'm going to tell you that based upon what I know about the claim, there is no loss. I mean, there was no covered loss under the policy. But it doesn't matter whether the coverage decision was correct. It matters whether the insurance company did an appropriate investigation before it denied the claim. Now, if an insured calls up the insurance company and says, I have a flooded basement, or the water came in through the walls, or I don't know how the water got there, but I'm sorry.
I'm gonna jump in here for one. I'm gonna finish this. I'm gonna jump in for 1 second.
It was feedback. Somebody was listening to my presentation. If the insurance company doesn't do an inspection, what's their basis for denial? Now, can the denial be based solely upon what the insured says? What if the insured is wrong? And if they take the position that a coverage decision can be made based solely upon what the insured says, then why don't they do the reverse and provide coverage for a claim based solely upon what an insured says? But no, they're only using it to their advantage. So an insured calls up and says, my basement is flooded. We don't cover floods. It's not covered in your policy. Technically, it's correct, but it's also bad faith. Because by definition, water in the basement's not a flood. That has a specific definition within the insurance community that applies. It is not when you have water in your basement in general. I mean, there may be a time when a flood might result in that, but this is not a flood. So why does an insurance company say flood isn't covered under your policy? Deny the claim. Now, it's possible that had the insurance company send somebody out to do an inspection, and by the way, it's their duty under the policy and under the law to actually do an investigation to make a coverage decision. Now, the insured may not know what caused the loss, but if the insurance company had gone out and they had done the inspection, they may have found that there was a broken pipe that had caused the water in the basement, and it might have been a covered loss. Here's why that's important. It doesn't matter if the coverage decision was correct. It matters whether they had a reasonable basis to deny it at that time. At least under Pennsylvania law, even if their coverage decision was ultimately proven to be correct, it can still be bad faith, because at the time they made the coverage decision, they didn't have enough information to base it on. They didn't have a reasonable basis. Now, the two claims that I'm going to talk about that I'm actually handling, one was a claim where there was water in the basement, and I believe the clients actually saw the water coming through the side walls, the basement walls. Clearly not a covered loss, but they covered it, but they denied the claim without an inspection. And I personally, after the claim was brought to my attention, wrote to the adjuster 6 times and said, what was the basis for your denial? What were the facts that you based your denial on? You didn't do an inspection, so and I never got an answer.
Well, Steve, let me ask you this question. Let's say the insured calls the carrier and says there was water coming through the walls. Do they still have to do an inspection?
I believe that they do, because the insured can always be wrong. Yes. Well, under those circumstances, they've done a little bit more of an investigation. It was where the insured said the water was coming through the walls and then had pictures which showed the water coming through the walls and was sent to the insurance company. At least they had some rational basis for it. Because, and it wasn't done simply on the word of the insured. But the second case actually, to me, is more interesting. The second case was more along the lines of being steered into saying that there was a flood in the basement. And I'm sorry, I said the insured was steered into giving words that would give the insurance company a reason to deny the claim. And we've all seen this, where the insured calls in the claim by themselves and says, I'm not really sure where the water's coming from. The insurance company, well, could it have been an overflow from your sump pump? Well, it could have been. Well, we don't, that's not covered under the policy if they deny the claim. Could it have been coming through the walls? Yeah, well, it could have been coming through the walls. I don't know where it came from. Well, we don't cover that either. So they're being prompted to give a response that is designed to allow the insurance company to deny the claim.
I'm just to jump in here real quick. You know, the term bad faith is it's a strong word. It's a strong phrase. It's a strong concept. And what I've noticed is a lot of you guys, when you write your letters, you know, when you're trying to get a claim, you know, covered, you know, you use the term bad faith as if you're trying to scare the adjuster. Now, I would suggest that you give them an opportunity to right their wrong, and then you can use the bad faith phrase. Because if they made a mistake, it's not bad faith. If you told them about it and they did not fix their mistake, that's when there's bad faith. So you don't want to use the term too much to have it lose its meaning to these people. You want them to know what you're talking about. So give them a chance to write it, and if they don't right the wrong, then you nail them. And then maybe, you know, maybe they'll jump, maybe they won't.
Now, Scott actually anticipated the next portion of my presentation.
I did not.
Because that's almost exactly what I was going to say, just with a little bit of a supplement. Now, many of you have heard me speak before, you've heard me harp on the idea of documenting files. And I harp on that for two reasons. The first one is that very often you will find that adjusters don't respond to the letters or communications, and that can be used to our advantage. But the second reason is that exactly what Scott said, which is it creates the difference between a mistake and intentional conduct. If an adjuster makes a mistake and we get it over to us and we want to allege bad faith, we're going to lose. I turned it off. We're going to lose under those circumstances because the adjuster comes in and says, wow, I may have been wrong. Maybe I made a mistake. So they usually don't. They usually, keep your. I'm gonna turn it off. Okay, sorry, my apologies.
We had an associate of ours who was listening, so she was trying to learn a little more about bad faith also.
My apologies.
Yeah.
Anyway, it's off now.
Now she's not listening.
All right. So now, when they, we often will find that they will double down on their mistakes, and that's good for us because they generally won't admit their mistakes. But if you give them the opportunity to correct their mistake, only one of two things can happen. They won't or they will. If they will, you can avoid going to litigation. If they won't, it makes the difference between a mistake and an intentional act. Because now they have been advised of the fact that their coverage position is correct with authority to support the position.
Right. I mean, right. People are human, and humans do make mistakes. But when you explain to them what their mistake is, and you're pretty, darn sure that you're right, then they have the opportunity to fix it or stand on their heels and say, no, I'm not changing my mind.
Now,
which happens a lot, more often than not.
this is one of the reasons why I've suggested in the past, when an insurance company, when an adjuster denies a claim for a reason that's clearly incorrect, and we can all come up with multiple circumstances where it happens. If you provide them with an attorney's opinion coverage letter, or even an opinion from somebody else who used to be in the insurance, on the insurance company side. And I know a few people who are public adjusters now who used to work for insurance companies. Those opinions may carry more weight. And even if they don't carry more weight in terms of them reversing their coverage decision, now I have a legitimate basis to go in and say to an adjuster when I'm cross-examining them, during the adjustment of this claim, didn't you get a report from, well, me, for example? And he go, yeah. I said, and you didn't change your coverage decision, did you? No. Why not? Well, I didn't think you were right. Well, did you take my report and did you give it to an attorney to see what the opinion? No. Did you take it to your supervisor? No. So basically they ignored the report because it was contrary to what they had already decided. Well, at that point, you have arguable bad faith. Ignoring evidence that is contrary to their coverage decision is a basis for bad faith.
But again, I wouldn't say it's bad faith if you don't change your mind. Give them the option to change their mind first, and then you hit them with the bad faith.
And I agree with Scott, and that was part of what I was going to say, which is try not to use the word bad faith. It is, you trivialize it, and if you are wrong, it undermines your credibility with regard to future cases.
Exactly. That's exactly
You allow the attorneys to use the phrase bad faith. And there's another reason why too, and it doesn't really apply that much, I think, in the property damage realm, but there's a different statute of limitations for bad faith than there is for coverage claims. And it is possible, and I've seen this happen, it predominantly happens in the uninsured motorist claims, but if an adjuster or somebody uses the word bad faith in a letter to the insurance company, it may trigger the beginning of the running of the statute of limitations.
That's correct.
And you may have problems later on. But it's really not applicable. In your cases, I'm throwing it out there solely because of the fact that it is an issue in some cases. Now, it could be an issue in any state where they don't use the coverage, where there's an actual statute of limitations, as opposed to a loss cover. A provision in the policy that provides for a certain amount of time. Now, for example, if in states that have a 3-year mandatory statute of limitations on property damage claim, if there's a 2-year statute of limitations on bad faith, if somebody uses the term bad faith, it may start the running of the statute of limitations, and by the time it may get to an attorney, that statute of limitations may already have been expired. So you have to be careful about using phrases. And of course, those of you who've heard me talk before, I always talk about making sure you're not inadvertently practicing law without a license, because then of course, there are potential problems with that. If you have an attorney send a letter, of course, that always protects you as opposed to you saying something yourself. Yes. He asked if he's opening himself up for slander. My answer to that question is no. And the reason why I think it's no is you're not stating, first of all, in order for something to be defamatory or an action for defamation, it has to be something that's published. And by published, I don't mean that it's in a book or in a newspaper, but it has to be out there for the general public to see, or at the very least, people outside of the conversation. So if you were to say to an adjuster in a letter, you've acted in bad faith, and it only is seen by him and it's not broadcast generally, there's no basis for a defamation action. But more importantly, it's an opinion. It's not a statement of fact. In order for there to be a defamation action, whether it be libel or slander, and the difference between libel and slander is libel is written, slander is spoken. The difference between those, you have to have a statement of fact and not an opinion. So even if you would have to say that let's say you made a statement that you lied to me about the amount of coverage that was in the policy. And there's that's a statement of fact. That is different from saying that I think you acted in bad faith, which is an opinion. So although I'm not concerned about libel and slander generally in this area, that's the significant difference. But
The easy answer is no. Just don't take a billboard out and say that, you lied to me.
But if you were to circulate a letter to other public adjusters that said Joe Schmo from State Farm lied to me about something, and you should be very careful when you're dealing with him, that is much more likely to be actionable, but there would still have to be damages.
If it's not true.
If it's not true.
If it's not true.
How does it work if a upset consumer takes
Again, I'm not going to sit here and say to you that I'm an expert on libel and slander, but it's going to depend entirely on the basis of the statement, number one. Number two, whether it's true. And in those circumstances, with all due respect, nobody's going to sue the consumer. They're going to sue the station that aired it. If the station, particularly if the station didn't double check.
That's also someone's opinion too. It's not fact.
Well, that's what I was saying. It depends upon.
Right.
It depends upon the nature of the statement. If somebody comes out and says, I think State Farm is a horrible insurance company, and I think Joe Schmo is a horrible adjuster, it's an opinion. It's not actionable anyway. But again, if it's a circumstance where he gets on the stand and says, Joe Schmo did something that wasn't true, and it has to be something that in and of itself is not just false, but it has to be in some way defamatory. And if he says Joe Schmo had an appointment with me on January 1st or January 2nd and didn't show for it, is it defamatory? Even if it's not true. But again, the average person really doesn't have any concern about being sued for defamation under most circumstances. Now, oftentimes, it's the insidiousness of certain decisions that are being made that are intentional and designed to drive the value of the claim down. For example, I had a case years ago where an adjuster from, again, Allstate, wrote to replace all of the hardwood or laminate flooring in the living room. but refused to write to bring up the quarter panel and but how are you going to replace the how are you going to replace the flooring without removing the quarter panel? You know, so these are little things that when you look at the components that are omitted, they often result in large savings to the insurance companies because they're not just done in one case. They're done in case after case after case after case after case. And if you save $40 here and $40 there, and all of a sudden you add it up and it's $1,000, like I said, $1,000 times a million claims is $1 billion.
Steve, what about the letter that we've all seen to the insured that denies the claim before Metro gets involved? It denies the claim and it lists 2 pages of nonsense. And maybe one of those lines is what they're talking about. But when you have, you know, an insured who, you know, is reading this letter and they're reading, you know, 3 pages of the policy that's put in this letter and saying that's why your claim is denied, is that bordering bad faith?
In my opinion, it does. It's unlikely that a court is going to agree with me on that. But the more important thing about that is that they omit the facts that they're relying upon to say that the claim is denied. It's one thing to give a laundry list of exclusions that are in the policy, most of which don't apply, and almost all of which the insured is not going to understand. But when the insurance company doesn't even put the reasons for the factual basis for the denial to say, you know, like they'll give the laundry list, and let's say it includes material misrepresentations. If they don't include the statement in there that says, you know, our investigation revealed that there was no hailstorm on the date that you claimed the loss was for, therefore, when you said it was damaged by a hailstorm, you misrepresented a material fact.
Okay, speaking of a hailstorm.
Yes.
July 6th last year, there was the big hailstorm up in North Jersey. I know a lot of you have a bunch of those cases. And let's say New Jersey manufacturers accepts a claim for this homeowner for the same type of loss that the next door neighbor had, where they denied the claim, saying that there's no damage to the roof because, you know, it didn't lose its functionality or whatever. But this one next door, they decide to pay for, and you know about it. Is that bad faith?
Well, the one word that you used that gives me a reason to say that there is potentially bad faith in that case is the word functionality. Now, and the reason why I say that is that there are very few cases in the country. There's 6 that I'm aware of, 2 that I was personally involved with, and both of those were cases where I wrote motions and got opinions in New Jersey that described what was covered for hail damage under a policy. Now, in both of those circumstances, there was cosmetic damage where the insurance companies denied the claims based upon cosmetic damage, saying there was no functionality loss, there was no structural damage. Now, putting aside the fact that cosmetic damage in and of itself may be functional, it may be structural damage, unless the policy itself says we're limiting, you know, we're excluding cosmetic damage from our definition of damage for hail damage, the courts have said that that is a covered loss under the policy. Now, so where it becomes bad faith under those circumstances is they're using a definition of hail damage that was probably written by Hague. There are probably people who are Hague certified who have defined hail damage as only with structural or functional damage and leaving cosmetic damage out, which is not the same definition that's applicable under the policy. But I'm going to go one step further and say that there's case law from the United States Supreme Court. And if I was maybe 10 years younger than I am now, I'd probably remember the citation. But there's case law from the United States Supreme Court that says an insurance company is bound by the laws of the state in which they issue policies. Now, to me, that means that every insurance company is required to know what the laws in their states are and comply with them. So if you have case law in New Jersey, Pennsylvania, New York, that says that cosmetic damage from hail is covered under the policy, and you have an insurance company that does not have an exclusion for it, and they deny it based upon the fact that it's cosmetic damage, I would say that's bad faith under the policy, even though it may only be a mistake, because they are conclusively presumed to know the laws of the state.
Okay, so let's take this one step further. Back to July 6th of 2020, huge hailstorm up in North Jersey. Now, New Jersey manufacturers, let's just say, because we have lots of claims against them, I don't understand why. But let's say that they're made aware of a lot of their homeowners making hail damage claims to the roofs. Do they have a responsibility to contact their insureds that live in that area to check to see if there's damage? And if they do have that responsibility, they don't do it, is that a potential thing?
I've never read any case anywhere that would put that requirement upon an insurance company to go out and say, hey, you might have a claim, why don't you make one for us so we can give you some of our money? I've never heard of that happening, or never heard of that requirement. The only insurance company I've ever heard that may do something like that is USAA.
I understand we've never heard of that happening, but do we think that maybe they should? I mean, they're insuring these people. They're taking their money. They're saying that, we're going to protect you. Do they have, and they know that there's a storm that potentially ravaged their community, whether it's hail or.
I'm going to say no. I really genuinely don't think that would be the case. And, but part of that, honestly, may depend on whether it's a publicly held insurance company. And the reason is that if it's publicly held, if it's a corporation that's publicly held, they still have a duty to their stockholders. And the question at that point is, what would it cost them to go do that, and whether it would be a violation of their fiduciary duty to their shareholders? It's a very complicated question that you're asking. My opinion generally is no. And, I'm going to go back to the idea, even in a covered loss. That claim that I told you about, where they paid the policy limits and it was on a fire loss, but they didn't pay for the debris removal, but nobody asked them for the debris removal. Does an insurance company have the obligation to pay for a benefit that was never requested? I'm going to say my heart tells me no, my brain tells me no, but it is something that I'm not aware of ever being litigated. And it's worth taking a shot at the argument. I'm just saying I don't know of any authority for it one way or the other. Bill, do you have a question?
I'll make it easy. I'll use the mic. So the unfair claims practice that regulates the operations of claim activity in every state has very specific rules with how claims are handled.
Right.
Most of those rules have statements to the effect of pertinent communication replies within 2 to 5 days, or the requirement to disclose coverages to the insured.
Right. The
ability to provide documents upon request and timeframes to respond for other actions in the policy.
Right.
There's, as you said in the very beginning, there's never been a claim that you haven't seen an action of bad faith or handled properly, basically, in a claim. When we begin to call the carriers out for their failure to comply with these basic rules that have been laid out in each state's Unfair Claims Practice Act, if they're illustrated throughout the claim process and documented, is that a big assistance to you in putting together a claim at the end for ultimately being compensated for the bad faith?
As with all questions asked to any attorney, the answer is it depends. I'm going to tell you that one of the reasons why insurance companies like to remove cases to federal court, at least in Pennsylvania, the federal court have said that's not a basis for bad faith in Pennsylvania. There are no cases that I'm aware of in state court. Now but actually let me backtrack a little bit because this is an important distinction. When a case gets removed to federal court, those decisions are not binding on the state court. So they are predicting what the Pennsylvania Supreme Court would do if it was given that opportunity. There are no cases in state court that have ever ruled on that, and I have many, many times used the Unfair Insurance Claims Practices Act, whatever the term is, it varies from state to state, and the requirements in there, and I've actually pled them in complaints that, here are 10 different communications that were sent by the public adjuster that were never responded to. There's an obligation under this. In fact, in the case I was talking about earlier, where I personally sent 6 emails to the adjuster asking for an explanation for how he could deny a claim without an inspection, didn't get a response. That I put that in my complaint when I drafted the complaint, that there were multiple communications and that this was a violation of the act. One of the problems with that, though, is that the act is not designed for bad faith. The act is actually designed to punish insurance companies when they have a repeated history of engaging in those acts. And when you look at it, it says the insurance commissioner's office can sanction the insurance company for multiple engaging in this, where it gets to the point where it's like a practice of the insurance company. And the statute itself does not give a private cause of action for violations of the act, meaning that there's nothing in that gives me to say, well, they violated the act, therefore there's a cause of action. But to me, it's evidence that the insurance company is not complying with its obligations to the insured. And I have used the act on multiple occasions to get around the suit limitations provision, for example. Now, for those of you who are not aware of the specifics of the act, there's one section of the act that says if an insured is not represented by an attorney and it is a covered loss, the insurance company has the obligation to advise the insured of when the suit limitations period is going to expire. And the goal of that is to say, well, to prevent the insurance company from negotiating up until the date of the suit limitations provision, then cut off everything and, screw the insured because now they can't file suit. So there's that requirement in the act. I've also used the fact that the statute requires that if they're going to rely upon an exclusion in the policy, that they send out a written denial letter citing the exclusions that they're relying upon.
Steve.
Now,
finish your sentence.
I'm sorry, but going back to the first one about the suit limitations provision, I have successfully used that to file actions after the suit limitations period expired and saying that since they violated the act, they can't use it. They've waived it.
I forget what I was going to ask you.
Sorry, Scott.
Okay, well, we do have a question here, and then I'll.
So, Steve, will we consider it bad faith if the insurance company on a claim, if they decide that they want to partially deny some of a claim, and a month and a half later, the insured looks and notices that the insurance company decided to open up 3 claims for them without them even having any knowledge, and they ask that question, Their statement was, well, we figured that you had bad damages and they were going to get in touch with you.
Well,
Can I settle that case for you?
I don't know if you sent that claim to us, but we had a claim that exactly.
That's our
happened.
claim. That was him. That
Okay.
was his claim.
That we had that exact happen. I alleged, when I drafted the complaint in that case, I alleged that that was a bad faith, an act of bad faith. I believe that it would be because for multiple reasons. One is that it exposed the insureds to multiple deductibles. A second and probably more important reason is that it would have given them the opportunity to cancel the policy for having too many claims in a short period of time. And
Which is exactly what they tried to do. And when we filed suit on that case, attorney Jenny Phillips agreed with us and was embarrassed as hell and settled the claim right away. And dropped the other three claims.
so
also.
I think that was an act of bad faith for multiple reasons.
I think they did too.
Keeping in mind the fact that at the heart of bad faith, at the heart of it, is the idea that the insurance company shouldn't be doing anything intentional to harm the rights of their insurers.
Okay, so you say that. Now, in New Jersey, again, we all know, and I'm not going to explain it again to you guys because then I get confused. The statute of limitations is not exactly a year in New Jersey, even though that's what the policy says. Now, the carrier knows that that's case law in New Jersey, that the statute is extended while they're investigating the claim. But they still put in the denial letter, you have up to 1 year, the date of loss, to file a lawsuit. Now, that's not true in 99.999% of the cases. That's a factual lie.
It is.
What do you think about that?
I think if an insured relied upon that and didn't file a claim, and then subsequently realized that the suit limitations provision would have expanded the claim, but then lost the opportunity to file suit, I would think that that would be an act of bad faith and a basis for damages.
So it's not so much that they said it, you have to act upon it or not act upon it. Relied upon it. You relied upon it and didn't file suit, and then you're screwed.
Yeah,
So,
well,
because there really is no damage if we get involved and we're allowed to file a lawsuit anyway.
but the problem with that, Scott, is that if I am correct in terms of my understanding of the bad faith law in New Jersey, that would have been a claim that was partially, strike that. If that would be great for bad faith in Pennsylvania, but of course the law is different in Pennsylvania. But in New Jersey, I'm not so sure because they didn't deny the claim. Now, I think personally that it should be considered bad faith in New Jersey, but the law is pretty strict there. Yes. Well, that's not necessarily their intent because they are saying that that's what's in the policy, and clearly the insured would not have suffered any damage if they relied upon that and then brought suit within that 1 year. But the question becomes, if it would have been a year and 3 months, and they didn't know that, then and relied upon and said, okay, I'm beyond 1 year, and they don't file suit when they still have another 2 or 3 months to file suit, and then they can't file suit. At the very least, it might be an equitable consideration for the purposes of having the suit considered filed timely.
Steve, I have two cases where the client was paid by the insurance company. One was $10,000, and I don't know, a week later, before the check cleared, they canceled that and they said they're denying the claim. So is that detrimental reliance? I mean, she relied on that and so on and so forth.
Detrimental reliance is actually a lot more complicated than people think it is. It is not simply that an insured, that the insurance company made a promise to the insurance company, and typically is when they say, okay, this is a covered loss. That's typically what happens. And then they turn around and they say it's not a covered loss. It's not detrimental reliance unless the insured actually relied upon that statement to their detriment. And maybe they went out and they got a contractor to begin the work. And now they're bound by a contract that they wouldn't have been bound to otherwise. But you have to balance that against the fact that every insurance policy has a requirement to maintain the property. So if, for example, it was something that was a necessary repair to the property in order to make sure the property stays in an insurable condition, then they have the obligation whether they relied upon it or not. The argument may be, though, under those circumstances, that because the insurance company said, we're going to provide this as a covered loss, they went out and they hired a contractor as opposed to a handyman. Because if the insured was told from the get-go that it wouldn't have been a covered loss, they might have hired a handyman, which would have cost them a lot less. So under those circumstances, at least the argument could be made that the insurance company may be responsible for the difference between what the handyman was going to charge and what the contractor was going to charge.
All right, we gotta wrap this up. We have to wrap this up in about 2 minutes.
Yeah, that's a good question. I've seen that many times. And what he's asking about, and I'll give you the classic example. You have roof damage. The insured goes out and does a repair to the roof in order to prevent water from coming in, which is in compliance with the policy to mitigate damages. But the insurance company comes back and they deny the claim because they didn't have the opportunity to inspect. I have successfully argued, I'm not saying it's bad faith, but I've successfully won breach of contract actions based upon that. I have at least gotten past motions to dismiss on that issue on the bad faith, but it's going to depend upon the investigation that the insurance company did before they denied the claim. Now, for example, we have the contractor who patched or fixed the roof. If they don't contact the roofer, or they didn't, or if let's say the roofer had pictures, or let's say this, if they did not exhaust all opportunities to find out about the to find out whether it was covered and deny it, I think that is an act of bad faith. I've gotten past motions to dismiss that, but I've never actually litigated the issue.
All right. So that's it for the hour. We appreciate your time. Thank you, Steve. You were fantastic.